Hi, I'm Willem and I'm the mediator. Mediation is the process where two or more people involved in a dispute come together with the help of a neutral third person to try and resolve their problems. This third neutral person is called the mediator. The mediator is trained in conflict resolution. Unlike a judge, the mediator does not make decisions about the dispute. The mediator does not have the power to force disputants to do anything. Any agreement and solution reached are the results of the disputants coming to an agreement. The mediator's job is to help the disputants evaluate their goals and mutual interests in order to find compromises and options for their own solutions. The mediator will ensure that any agreement reached complies with every aspect of the law. The agreement reached is binding by law and is highly recommended that the settlement agreement is made in order of court. When a case is mediated, the disputants are not giving up their legal rights. If no agreement is reached, the disputants are free to pursue other legal ways to settle their disputes. In South Africa, since 9 March 2020, it is compulsory that all cases attempt mediation before litigation. If parties feel that mediation is not going to work, they, together with the mediator jointly, declare in an affidavit the reasons for failing to pursue mediation. The question arises, if the disputants are in control of the outcome, why have a mediator? Well, as it is in sport, politics, and any other situation where there is some kind of conflict, competition, or a difference of opinion, a qualified third person in the form of a referee, a chairman, or in this case a mediator, is necessary to ensure the competition, debate, and arguments are following the rules, are within the law, and that the outcome is a result of fair play. Without the mediator, chaos will erupt, and the original conflict may escalate, and the situation worsened. There may be a lack of trust between parties, an unwillingness to give in to the other party's ideas or suggestions. Disputants often just need someone to help them take a step back and evaluate the issues and identify creative ways of solving these issues. Mediation also serves an important psychological role called catharsis. This means that often, before disputants are willing to compromise and settle, they need the opportunity to vent to each other, normally in the presence of a neutral third party, in this case the mediator. This opportunity to vent, to compromise and settle, when done properly with the expert help of a mediator, makes mediation very effective. The primary goal of mediation is for disputants to come to a mutually accepted agreement that they can all live with. The goal is not to work out where the truth lies, who is right or who is wrong, but to solve a problem. This is far different approach than is followed in litigation, where the judge makes a call on who was right or wrong and what should be done about it. In a sense, mediation does not consider the past but look at the future. Disputants may still have relationships in the future, and mutually agreed confidential settlements between disputants are much better than a victory of one over the other. Mediation also results in some secondary beneficial goals for the parties, especially where there is a continued relationship between the parties. There will be improved communications, a better understanding of the other party's point of view, get the opportunity to speak, be heard, and be understood. Opportunity for self-investigation of your and the situation you are in, strengths and weaknesses. Understanding other hidden issues or underlying problems, such as past grievances or personality clashes. Exposing and exploring creative ideas with the expert help of the mediator to take the relationship forward. In a court of law, disputants are deprived of these opportunities because during litigation, attorneys are arguing their case with the sole purpose of getting the best possible outcome for their client, a victory over the other. In court, disputants don't get the opportunity to address each other, which could resolve in differences and impact positively on their future relationships. There's a Chinese proverb that says, a lawsuit breeds a lifetime of hatred. Mediate, don't litigate. Litigation in court put former friends, partners, colleagues, spouses, neighbors, siblings, and other family members up against each other. The sole purpose of litigation is to have one winner and one loser. If attorneys do not pursue this goal, they open themselves up for malpractice suits. As I said, in South Africa since 9th March 2020, all disputes must first attempt mediation. The only obvious exceptions are criminal cases. All other cases can mediate with one important condition. All parties must be willing to try. Mediation does not guarantee an outcome, but research have shown that 90% of cases have an outcome. All cases for litigation, on the other hand, however, have only a 50% satisfactory outcome. Remember, each case in litigation has a winner or a loser, which means that only one of the parties is happy. Mediation offers more amicable way out of this animosity. For less money, time, and aggravation spent on a lawsuit, mediation can come up with a solution that everyone can live with. Mediation can be used in all kinds of conflicts, not just legal or contractual disagreements, but also social, cultural, religious, and personal differences within communities, families, and households. Parties don't have to have a legal grounds to sue another party. For instance, siblings fighting over the care of elderly parents, roommates disagreeing over maintenance to their accommodation, neighbors fighting over barking dogs, garden walls, etc., or co-workers not getting along. When deciding to mediate, it's important to consider the circumstances, goals, and relationship to the other party. There are various types of situations in which mediation can take place. Consumer versus a merchant, a landlord versus a tenant, a neighbor versus a neighbor, spouse versus a spouse, business partner versus a business partner, homeowner versus a contractor. Some disputes may not be handled through mediation because there may be specific mechanisms for these disputes, like bargaining counsel, ombudsman, arbitration as a clause in a contract. The advantages of mediation are many. It's quick. Once parties have agreed on mediation, the process is quick and can be concluded in one day. It's very cost effective compared to other methods of conflict resolution. It's confidential. Most proceedings in court is public, and so are the records and verdicts. Mediation takes place in a venue, normally outside court, with only the disputants and the mediator present. Before mediation, all parties sign a confidentiality agreement. If no settlement is reached, nothing from the mediation may be used in further litigation, and the mediator may never be called as a witness. Mediation is fair. In mediation, the parties draw up a mutually acceptable settlement. If one of the parties is not happy, then that party does not have to sign the agreement. Mediation is flexible. In mediation, only any issues related to the dispute may be raised and does not have to be a legal issue. And unlike a judge in court, the mediator and other parties will allow any issues to be raised which can bring understanding and perspective to the conflict. Mediation is much more informal process which reduces stress, using plain language, no legal terms. It's in a private venue where the disputants do the talking with to reach a mutually acceptable agreement as the goal. There is a no winner takes all scenario. Mediation is successful because both parties get what they agreed upon. In litigation, there's always some degree of dissatisfaction and anger by both parties. There may be a winner, but a lifelong relationship may have come to an end, with little or no chance of reconciliation. In mediation, there is no imposed solution. The mediator does not judge and cannot make a ruling, but only guide the parties to stay within the law. Parties themselves are in control of the process and the outcome. They reach a mutually agreed settlement. In mediation, there's no power imbalance. In litigation, the saying goes, justice favors money and power. Basically, it means that he who can afford it and have more knowledge of the law inevitably wins. In mediation, the mediator has a duty to keep the playing field level. Because the parties reach their own satisfactory agreement, the more powerful party is in no or in a little position to impose his or her preferred agreement on the other. If a party is not satisfied with the agreement reached and refuses to sign, there is no agreement. And then the question is asked is, why would parties agree to mediation, spend money and time, and then deliberately overpower or undermine the other party and the process? When does mediation make sense? Fortunately, mediation is available to everyone in a dispute, even when courts are not. Let's face it, taking someone to court is almost always a hostile act and damaging to any future relationship. Being slapped or hit with a lawsuit makes no sense, doesn't it? Any one of the following reasons is enough to try mediation. The law cannot provide the remedy you want. Courts mostly only hear disputes which can be solved by interpreting the law and making a ruling. For instance, when family members are in a dispute simply because of personality clashes, there is no right or wrong. It's very hard for a judge to make a decision on that. Second, you want to end a problem, not a relationship. Isn't that what disputes are all about? Is to end the dispute, not necessarily to end a relationship. Your dispute may involve someone you need to stay in good terms with, either by choice or circumstance. Family members, co-workers, neighbors, siblings, etc. Mediation is not about finding fault, who was right or wrong. Mediation is about finding common grounds for a relationship in whatever acceptable form to carry on. Thirdly, your dispute is no one else's business and you want to keep it that way. Court hearings are in open court with strangers in attendance, possibly reporters. Nothing said in court is confidential and may become public knowledge unless a judge rules it not to be. Mediation, on the other hand, normally takes place in a venue outside of court with only the disputants and the mediator present. The parties sign a confidentiality agreement before mediation commences and the settlement is not a public record. If mediation fails, nothing said during the mediation may be used in court and the mediator may never be called as a witness. Think of the benefits of having a mediation hearing in which private intimate sexual evidence or private financial evidence is led. It is totally confidential. At the end of mediation, the mediator may ask the disputants to hand over all notes and have it destroyed. The only time mediation proceedings are not confidential and would probably cease is when abuse or other obvious criminal actions come to light. The mediator is compelled then to disclose this criminal evidence to the authorities. Fourthly, you want to save on costs. One of my fortune cookies says, going to court is like losing a cow for the sake of a cat. Often, in lawsuits, it costs far more to prove a point than what it's worth. Often, after a court case, the disputants may find themselves in financial difficulties, which may take them years to recover from. Mediation's cost is a fraction of litigation. Mediators, as I do, often charge a flat fee, depending on the complexities of the case, for the whole process, but with a time limit, instead of an hourly fee. Fifth, you want to settle your dispute quickly. Taking your case to court can be a very lengthy process, waiting for court dates, having postponements, etc. Mediation, once both parties agree to the process and the administration process had been completed, can be resolved in one day. Mediation is also not restricted to certain hours, but can be done at the party's convenience, even after hours and over weekends. Parties in mediation also do not have to be in the same room. Mediation may take place with internet tools such as Skype, Zoom, WhatsApp, internet, etc. And by the way, during the lockdown, we are now authorized to do mediation without any of the parties presently together. In the past, it had to be the mediator and one of the parties, and the other one could be on Skype. Now all parties can be in separate locations. Excuse me. You want to avoid a legal precedent. You may want to avoid going to court because you doubt your chances of getting a favorable verdict. In mediation will help you get an acceptable outcome. Remember, there is not a one loser or one winner. It is an outcome that will satisfy all parties. Seventh, you have difficulty initiating negotiations or you lack negotiation skills. When you have a formidable opponent who is intimidating, the mediator's presence will allow you to negotiate in a safe environment and help you put your points across clearly to the other side. The mediator has a duty to ensure a fair and safe process with no intimidation, threats, or bullying. Lastly, research has shown that mediated settlements last and are honored by the parties because the disputants themselves have negotiated and reached this mutually acceptable agreement. The satisfaction and feeling of achievement is satisfying and gives the disputants a sense of pride and accomplishment. How to choose your mediator? Well, I'm a trained, fully qualified specialist mediator. The focus of my training is on mediation skills. My specialty is relationship conflict, family law, co-workers, neighbors, church, social clubs, etc. Psychologists, social workers, pastors, and attorneys who have the prescribed training may also operate as mediators. These mediators, with all respect, are trained in their field of expertise first and secondly as mediators. These mediators who mediate in cases where they have had some form of contact with one of their disputing parties, often it's a client of a psychologist or a party in social work or an attorney's client. So these mediators often find it very difficult to be completely neutral. However, I, as a specialist mediator, often call on their expertise to assist in complex cases where their knowledge is important to allow disputants to understand their issues. I've been a paralegal since 2004, and this background helped me understand the legal processes. Mediators must know the law, and we operate in the shadow of the law. Mediators must ensure that all agreements comply with every aspect of the law. I'm registered with ADR International and may operate as a family law mediator anywhere in the world, as long as it's primarily in English or in South Africa, also in Afrikaans. So for a quote, contact me, Willem de Villiers. I'm also the mediator on Facebook, where all my contact details are available. So mediate, don't litigate. Thank you. Goodbye.